Hello, my friends. Welcome to a brand new episode of the Christ and Coffee Podcast, uniting Christians one coffee hour conversation at a time. Today, we're going to talk about the First Amendment and three very important Supreme Court cases that took place the past 2 years. I'm surprised they didn't get enough media attention, but today we're going to dissect what they are and the ramifications of them with legal expert Mark Movsesian. Mark is the co-director at the Center of Law and Religion at St. John's Law School. He's a contributor to First Things magazine, and he even has his own podcast called Legal Spirits. But before we jump in today's conversation, can you do me a favor? Please like, subscribe, comment on whatever platform you are listening to this podcast on. It will do wonders for us to promote these conversations. We're on Facebook, we're on YouTube, we're on Spotify and Apple Podcast. I am just grateful that you're listening into these programs, and I hope to provide great conversations like the one you're about to hear in the future. So thank you so much. Grab a cup of coffee and enjoy this conversation. Hey, Mark, so good to see you. Thank you for joining the Christ and Coffee podcast. How are you doing, my friend?
Oh, we're fine. I'm fine. Thank you for having me, Hike. I really appreciate being with you.
I would love that fact that you're here because as a pastor, I often get asked questions about religious freedom related things on both extremes, people not knowing their rights or people assuming that people can't practice their religion in many ways. But the First Amendment seems to be a safeguard for what makes America great. I know my dad loves freedom coming from the Middle East. I know people who've come from places where they're not able to express themselves, in specific their religion. So what is the First Amendment? How would you define that?
So the First Amendment to the U.S. Constitution is, I'm sure a lot of your listeners know this, is the First Amendment in the Bill of Rights, which was adopted in 1791, so a couple of years after the Constitution was adopted. You know, when the Constitution was adopted, a number of people complained about the fact that it didn't contain specifically a Bill of Rights. The Federalists who supported the Constitution said it's not necessary because the government is so limited that it can't really do anything anyway. But the deal was, we'll pass this Constitution and we promise that we'll include a Bill of Rights later. So one of the first things that the very first Congress did was pass 10 constitutional amendments. Actually, there were 12. Two of them sort of went by the wayside, which became known as the Bill of Rights. And the first one is the amendment that deals with, among other things, freedom of religion. And the religion clauses of the First Amendment, there are other clauses too, like the free speech clause, but the religion clauses of the First Amendment say that Congress shall make no law respecting an establishment of religion or limiting the free exercise thereof, or prohibiting the free exercise thereof. I have to go look at the exact language, actually. I'm a little embarrassed. But there are two clauses. One of them is the Establishment Clause, which says Congress shall not make any law respecting the establishment of religion. Now, what did establishment of religion mean? To the framers, it probably meant something like the Church of England, you know, an official state religion, an official state church supported by the taxpayers, ministers appointed by the government. Congress would have nothing to do with that. Now, the states at the time, a number of them did have established religions. In fact, Massachusetts had one until 1830, but they eventually went out of practice. And in the 14th Amendment, which is adopted after the Civil War, the Supreme Court has said Congress incorporated the Establishment Clause against the states. So the states can't have an established church anymore either. The other clause that says Congress shall make no law that prohibits the free exercise of religion, that is the Free Exercise Clause. And that was incorporated against the states in the 1940s, according to Supreme Court opinions. So both of those two clauses, the Establishment Clause and the Free Exercise Clause, are what we think of as the religion clauses which provide for religious freedom in the United States.
Great. So I hear this expression a lot.
Can I just say, Hike, just one more thing before I forget, and that is, just so your listeners understand this. So these two clauses are thought to work in tandem. The Establishment Clause says the state can't set up a religion, and the Free Exercise Clause says the state can't also prohibit individual citizens from exercising their religion, right? So those are two sides of the same coin, really.
So, and this is coming from a lot of the people, immigrants coming from Europe. They didn't want state religions, primarily the Church of England. They're coming to America. You have different parts of the country, like the Pilgrims with a certain congregational Calvinism. You have the Quakers and in Pennsylvania, sort of things. You have different pockets of the colonies wanting to escape sort of these persecutions, whether it's like the Huguenots in New York with the Amsterdam. They're coming from a place where they're feeling this resistance. Is that correct?
Yeah.
There's a history, a narrative to trace this thing from it.
Okay. Well, we can go back.
They're reacting towards something.
Sure. You know, Heike, we can go back further than the Constitution, and it's a really interesting point that you make. So the United States was founded by, in many respects, by people who were fleeing religious persecution in Europe. And they came to the United States to be able to worship God as their consciences directed them. Now, it's not quite fair to say they were opposed to all established churches, because the Puritans in Massachusetts did establish their church.
Yeah.
And as I said, that lasted until the 1830s. And as I'm sure you know, there were differences among these groups. I mean, the Congregationalists saw things differently from the Baptists, who saw things differently from the Methodists. And there were differences. But what's really interesting is what historians will tell you is one reason that the First Amendment grew up in the United States, that we have a First Amendment in the United States, was the social reality of the founding of the United States, because there were so many different religious groups. Now, to be sure, they were mostly under the umbrella of Protestantism, but there were so many different religious groups that none of them, even if they wanted to, none of them really could impose itself on everybody else. And so religious pluralism is in a way, is the social fact that leads to the legal construct of free exercise of religion.
Right.
You know, and it's also very interesting in American history how you have these two streams. There is the Enlightenment stream, which is, you know, very skeptical of religion, very into rationality, and you know the deists like Thomas Jefferson and Benjamin Franklin and so on. On the other hand, you also have the evangelical Christian stream, people like Patrick Henry or Sam Adams or John Jay, others. And both of these groups supported religious freedom for different reasons. The the Enlightenment types like Jefferson, they were skeptical of religion generally. They didn't like the idea. They thought that we have to protect the state from the corruption of religion, from the religious fanatics who would take it over. And the other side, the evangelical Christians, and this goes back even to Roger Williams, they thought we have to separate church and state in order to protect the church. They weren't concerned about the state being corrupted. They were concerned about the church being corrupted. But both of these two groups, both of these streams merge together and give us the American ideal of no establishment of religion and free exercise of religion.
Yeah, and that's a great point, because I oftentimes hear that there's this debate: was America founded on Christian principles? Was it a Christian nation? And it's kind of a both and. Yes, there's some factors of that, but there's also this secular side also being some of the founding fathers. And like you just said it so eloquently, they had a common interest in having these clauses implemented for different reasons.
For totally different reasons. I mean, as I say, people like John Jay or Witherspoon or some of these founders, they were very serious Christians, and they weren't concerned about that Christians were going to contaminate the state. They were concerned that the state was going to contaminate religion, right? And on the other hand, you had other people who thought, we've had hundreds of years of religious wars in Europe. We don't want them here. And we want to keep kind of religious enthusiasm, religious extremism out of our government. And they kind of both work together. And, for much of our history, we have avoided, I think, serious religious conflicts for a couple of reasons. I mean, one is the First Amendment. The other is the fact of pluralism, and also the fact that people could move. So like Roger Williams, when the Puritans got irritated with Roger Williams, he moved to Rhode Island. When the Mormons started up in upstate New York and they ran into trouble with the authorities, they moved across the country all the way to Utah. So we don't necessarily have that escape valve anymore for this.
Right.
So we have maybe some more problems now. Also, all of these groups were really, as I said before, they were within the great umbrella of Protestantism. And so, even though they thought of themselves as different. I explained to my students in my law and religion seminar yesterday, in the 18th century, a Presbyterian marrying an Episcopalian would have been thought of as a mixed marriage, right? Like, what is this nice Presbyterian boy doing marrying this Episcopalian girl? But Tocqueville says this in Democracy in America. They were all Protestant Christians. And that also, I think, tended to tamp down conflict. But now we don't have that anymore.
But the other side of these two clauses is this ability to create your kind of own religion and not let it be touched or quenched down as some sort of new movement that's challenging the state. So you just mentioned Mormonism. You have some Unitarian Universalists, Jehovah's Witnesses. All of these are kind of also coming out of these sects, which wouldn't be considered a Protestant umbrella. They're considered outside of Orthodox Christianity, also emerging because of this sort of culture.
Yes, absolutely. They emerged because of the culture, as we said before, about the kind of frontier society where religious pluralism is just a matter of fact. And even if the authorities wanted to, they really couldn't stop these things. They grow from the culture, but they are also enabled by the First Amendment. Now, I don't want to paint too rosy a picture of this because, if you talk to Mormons or Jehovah's Witnesses, you ask them, what is your history in this country? They will tell you there has been a lot of state persecution as they perceive it. And, there's a very famous case from the 19th century where the Supreme Court said Mormonism is not a religion, right? It was a case involving polygamy. And it was a test case. There was a Mormon who said, who violated the bigamy statute and said, I have to do this because my religion requires me to take more than one wife. And the Supreme Court said, absolutely not. We have free exercise of religion, but it's ridiculous to say that polygamy is part of religion, So now they wouldn't say that today, I don't think. I mean, of course, we would the LDS Church, the Mormon Church, is considered a religion in America today. But I just want to point out that it is true we have these movements, and it's true we have the First Amendment. But people should understand that it hasn't all been rosy. It hasn't all been just one wonderful, wonderful celebration of religious pluralism in America throughout our history.
Right, and that's why we're going to have these Supreme Court cases to understanding what does this actually mean. But before we jump into some pretty big Supreme Court cases on this amendment that have taken place in the midst of the pandemic and I don't think they got enough attention as they should, and that's why I love to just kind of want to talk about these implications of these cases. I just have one more question in that regard. Where does this concept of separation of church and state come from? From these two rules? Because that's like often thing I hear when on people who don't like to hear about religion. They usually say, look, there's separation of church and state. Stop talking to me about Jesus or something.
Well, separation of church and state, it's a bit of a trick or a bit of a canard, because the Constitution does not say separation of church and state anywhere. The Constitution says that there's no established religion and that citizens have the right to free exercise, but it doesn't say anything about separation of church and state. The Supreme Court, in a famous opinion pretty early on in its history, in the 19th century actually, brings up this idea of separation of church and state. And they're getting it from a letter that Thomas Jefferson wrote to the Danbury Baptists, in which he said, I'm just so grateful that our Constitution embodies the separation of church and state. And the Supreme Court, it picked it up in one of its opinions, I think 19th century, maybe 20th century. I'd have to go back and double check. I'm pretty sure it's 19th century. Anyway, pretty early on. And they adopted that, and they said, okay, that's what the First Amendment means. It means separation of church and state. But most scholars would tell you that just isn't true. That is the Supreme Court, relied on a letter from Thomas Jefferson that is not part of the Constitution. That was Jefferson's understanding, but it doesn't mean it was what the Constitution said or what people ratifying the First Amendment thought. So to say that we have an absolute strict separation of church and state in America is not true historically. I mean, for better or worse, I'm just giving the empirical fact. It is not true historically. It is not required by the Constitution. It is not true today. I mean, if you really believed in total separation of church and state, then you couldn't have, in God we trust on the currency. You couldn't have the 10 Commandments monument in the Texas Capitol building. You couldn't have lots of things if you really thought. You couldn't have Christmas as an official holiday if you really thought that.
Yeah.
So it's never meant that.
Wow, but it's coming from this comment on Thomas Jefferson, but there was a Supreme Court case referencing it to kind of give it more
Exactly.
weight.
That's where it comes from. And it's funny why, historians have looked back at this and say, well, why? And apparently I think it was the Chief Justice at the time. His neighbor was a historian called George Bancroft. If you want, I can at some point send this to you. You can share it with your readers. There's an interesting article about this. Just a happenstance. The Chief Justice, his neighbor was a historian. The historian told him about this, and he said, "Oh, okay, that sounds good. That sounds right." And they put it into the opinion.
Amazing, because I feel like people know separation of church and state versus these two articles you just referenced. Just but it's not even in anything official.
It's not official.
Amazing.
I mean, look, it is a shorthand. It is true. I mean, so we don't have an established church. That is right. Yeah. And, we don't have official tests for office. It used to be the case in some parts of the world. I think it still is in some parts of the world, that in order to be a member of the government, to have a public office, you've got to swear your belief in a religion. We don't have that by our Constitution. But this idea that they must be absolutely, completely separate is not true.
But then there's these unspoken traditions, like every president swears on the Bible, regardless of what they may believe.
Right.
It's like an unspoken sense of
tradition. You know what the court has said about such things? They've tried, they kind of backed themselves into a corner saying separation of church and state. So what they do now is they often refer to those things as quote unquote ceremonial deism. That, okay, yeah, we have God we trust, and yeah, the president swears on the Bible, whatever, but that's kind of formalities, and also a lot of these things are grandfathered in. So for example, there's a case from a couple of years ago. We're not going to talk about it this morning, but there's a case from a couple of years ago involving a cross, a war memorial on public property in Maryland. And there was a big fight about this. A humanist group wanted the cross taken down because they said it violates separation of church and state to have such a big cross on public property. And the Supreme Court more or less said, this has been around a long time. It's pretty old. It would be more disruptive to take it down now. Most people don't really even notice it or think of it as a religious thing anymore. It's just been there so long, so we're going to leave it. However, I mean, the implication is, okay, if you try to put up a big cross like that today, that might be a different thing. So some of these practices, Hike, have been grandfathered in over time.
Wow. So let's talk about one of the cases that I've heard about a football coach.
Oh, yeah.
He, from my understanding, he would pray after games in the middle of the field, and he got fired for that. Is that pretty much the gist of it, or there's more to it?
More or less. This is Coach Kennedy. He's from out on the West Coast, actually, out from where you are. And he is a high school football coach. He teaches for a public high school. And he had a practice of praying on the 50-yard line after games. Now, initially, there was evidence, and the facts in this case were disputed. Even at the Supreme Court level, that people were still arguing what the facts were. But apparently in the beginning, he would invite players from both teams to come and pray with him. And then some people objected to that, and the school objected to that. And so he said, okay, I'm just going to do it by myself. I'm not inviting anybody to come anymore. I'm just going to go do a private solo prayer, private in quotes, right? Because it's in the 50-yard line. I'm going to go do a prayer. And of course, anyone who wants can come. I'm not pushing people away, but I'm not inviting anybody. And he got fired for that. And why was he fired? Because the school district said, according to Supreme Court case law, it is a violation of the Constitution if we endorse religion. That is, if the public school endorses religion. Okay. And what does it mean to endorse religion? According to Supreme Court case law, it means a reasonable observer would think that the government was favoring one religion over another. So the school district said, if people see you, the high school football coach, praying on the 50-yard line, they will think that we are encouraging this. They will think that the state is, in fact, endorsing your prayer, and that would be a constitutional violation, so we cannot allow you to do it. That's what the school said.
Okay.
And by the way, they weren't totally wrong in terms of what the Supreme Court had said up till that point. So then the coach sued under in other words, this is interesting, right? So the school said, allowing you to do this would violate the Establishment Clause, the first of the two religion clauses. And they fired him because he wouldn't stop. So they fired him. He then sued them under the other clause, the Free Exercise Clause. And he said, you're preventing me from praying, takes away the free exercise of religion. You have violated my constitutional rights. So in a way, there was a kind of conflict here now between the Establishment Clause and the Free Exercise Clause.
Fascinating. So then you said up till this point, the Supreme Court was leaning more towards you can't be endorsing religion.
Correct. Now they had several times hinted that maybe they didn't have that view any longer. That view comes out of the 1970s and 1980s. And they hinted, oh, maybe we're not going to take this view anymore, but they never quite said it. So he sued, it got up to the Supreme Court, and the Supreme Court did say it. They said that old view that we had, the endorsement test, is overruled. We don't have that view anymore. It is not a violation of the Establishment Clause because someone might think the state is endorsing a religion, okay? They said, in fact, we have to look to history and tradition to decide whether something violates the Establishment Clause or not. And they said, these prayers, in our tradition, this is not a violation of the Establishment Clause. You know, we have a tradition of honoring religious expression in public places. That's all this guy was doing. It wasn't a violation. So the school was wrong. When the school said, sorry.
So, because this is one person doing it. It's not like the school is saying we're not a public school anymore. We are this person's religion type of Christianity. We're endorsing it. And that's where I guess this connects to, is a school a personal entity? Does a person represent the school? Then are you dealing with individual
this was,
here?
Hike, this was a fight because the school district was saying, well, he is a public school teacher and he is on duty. This is, he's still on duty. The game is over, but he's still the coach and he still has responsibilities and, he shouldn't be able to do this. And his response was, I'm just doing this as a private citizen. And if being a school teacher means I give up my rights to free exercise, well, that would be unconstitutional. And the court agreed with that.
Right.
Now, there's another element, Hike, I want to point out, which is the court was very, very clear about this. They were very careful to say this, that there was nothing coercive about what the coach was doing. He was not asking the players to come and pray with him. He wasn't requiring them. He wasn't doing anything like that. And they said, or at least they implied, that if this were a coercive thing, then that would be different. The school could stop that, and coercion would violate the Establishment Clause. But he wasn't doing that. Now, the dissenter said, yes, he was. The dissenter said, if you look at the whole history of this, in the beginning, he had been inviting people to pray with him. He had been asking students to pray with him. And the students aren't going to forget that. So even if he is, no longer officially inviting them, they all know this. And, there have been cases in the past where the Supreme Court has said, particularly in the context of impressionable high school students, you have to be very careful not to pressure them to engage in religious exercise. And I kind of understand that. I mean, I could see if I were a parent in that school and the coach were leading prayers and my kid was on the team, I could reasonably worry that my kid is going to feel pressured to participate in this. And, I don't want that. I don't want that for my kid.
Yeah. I'm thinking as a parent, like, okay, this guy's probably Christian praying to Jesus. I'm like, amen to that. But what if someone was like praying to Satan or some other entity? Then I think the Christians would be freaking out if that was happening.
For sure. And
so this means any sort of this is the kind of the tension here. You have the freedom to worship whoever you want. So the football coach could do anything he wants. That's religion, even if it's a religion that may be endorsing violence or something.
Yeah, well, nature. Exactly.
Correct.
Right. That's a complication. And, logically, this would apply, you said, to a Satanist, or it would apply to, let's not go as far as Satanism. This would apply to a Muslim. This would apply to a Jew, to a Buddhist. And, I'm sure there are evangelical Christians who wouldn't like the idea that their kid is being pressured to engage in a Muslim prayer or a Buddhist prayer or something like that. And the logic of this opinion would suggest, as long as they are not, formally being told you have to do this, It's okay if on the other hand, look, if you're a Buddhist and you want to pray, then I see that too. These
Yep.
by the way, I should tell your listeners, this was a 6-3 decision. So there were 3 of the justices dissented and said, in fact, the school was right. This is an Establishment Clause violation, but they were in dissent.
So if this was like a Catholic school, is it okay to pray because it was a public school?
Sure, that's different. A Catholic school is a private school, and the state has no business telling the private school you can't have prayers, for sure. That really, if they did that, that really would be a free exercise problem. The problem came up here because he's a public school teacher, and the state is not a private entity.
What are some of the ramifications of this decision besides some of the stuff we were talking about? Like does this mean any football coach could go pray publicly in a public school?
So I would say the key takeaway for us law nerds is the fact that they finally overruled the endorsement test, right? So going forward, that test no longer exists. It's now a history and tradition test. In terms of what teachers or coaches can do, I think after this case, the theory of precedent, right? So in the American legal system, when a case is decided, its reasoning binds in subsequent cases involving similar situations. So if you have a situation where a football coach wants to go pray on his own, doesn't formally invite anyone to come with him, doesn't disrupt things, doesn't coerce anything, then I think he has a right to do that under the Constitution. Now, the facts might change. And I'm assuming the next time this comes up, the school is going to be keeping a very close record of, are parents complaining? Is there any kid who says, I felt I had to go and I didn't want to? By the way, that did happen in this case, except that was in the past. He changed all that. He didn't invite people to come any longer. But in a similar case with similar facts, yes, that means that, the school can't stop someone from praying on the theory that someone might misunderstand and think the school was endorsing it. By the way, it's also sort of funny. How could anybody think the school was endorsing this? They fired him, right? It's sort of ironic to think that anybody would think the school was behind this, but that's what they said.
Wow. Let's jump to another case. There's the related to schools and is it funding? The Carson. What's that case?
So Carson versus Mackin, this is also decided in 2022. I should have said the Coach Kennedy case was 2022, so last year. The Carson case is the last or the latest in a series of cases involving state funding that goes to private religious schools. Now, a while ago, this is another example of how the court has been moving towards, I guess you'd say, a more pro-religion stance in this current court than it was, let's say, 50, 60 years ago.
Right.
So the state of Maine had a program in which it would provide tuition assistance to parents who had to send their kids to private school because there was no public school in the district. And I guess in Maine, there are some school districts that don't have a public high school. So in those districts, the state of Maine would provide tuition assistance. And what it would do is the parents would designate the private school to which the money would go, and then the state would just send the money to that school. Except Maine said no tuition can go to religious schools, to private religious schools. So if you decide you want to send your kid to a private non-religious school, we'll pay for it. But if you want to send your kid to a private religious school, state funds are not available for you. And the Supreme Court said, this is, as I said, there's been a series of cases like this. This is just the most recent one. The Supreme Court said, again, by a vote of 6-3, that would violate the free exercise clause. That telling a parent you cannot use your money for a religious school would violate the free exercise of religion by the parent. Now, that's kind of an earthquake, given what the court used to say about such things. So why did the court do that? The court said, well, this is sort of an equality matter. The state of Maine has said it will give parents tuition assistance for private schools, except for religious schools. Well, that is specifically targeting religion as a status, or actually not only as a status, it's targeting religious use for disfavored treatment. So if you're a secular private school, you get the money. If you're a religious private school, you don't. That is discrimination against religion. And because it's the parents who are, through their individual free choice deciding where to send the money, that's not a violation of the Establishment Clause. That's not the state establishing a religion. The parents are deciding.
Right.
But the key thing is an equality thing, right? If you're gonna make public benefits available to everybody, you can't exclude people because they are going to use that money for a religious education rather than for a non-religious education.
Fascinating. So what were the so they went to the Supreme Court and they said, hey, Maine, let them decide they could support religious.
Hey, Maine, you cannot prevent parents from doing. You cannot exclude parents from this program. Now, I think this is a really big deal because, as you know, you have small children. There is a growing movement of religious schools in America. I should say there's a lot of pushback against the public schools in America because of what happened during COVID. There's a big private school movement. There's a big private school and a homeschooling movement. And many of these private schools are religiously affiliated. So what the court has now said is, okay, if the state is willing to subsidize private education, it cannot exclude private religious education. Now, I want to tell you, there was one interesting footnote in the opinion, because the dissenters said, well, what if the school teaches things that are discriminatory? What if the school says that marriage is between a man and a woman and that same-sex marriage is a violation of God's will? We don't endorse that. Many people would say that is discriminatory, and they won't want their tax money going for a discriminatory use like that. And the Supreme Court, in the way the Supreme Court often does, it dropped a footnote and said, well, we're not addressing that case here. Because Maine didn't say religious schools don't get the money if they teach discrimination. It just said religious schools, period, don't get the money, right? It is making a distinction just on the basis of religion as religion, and that's unconstitutional. We will leave for another day the question whether a state can exclude a religious school that teaches something that people find inimical. That's for a future day.
So I have a bunch of questions with that. So if you don't teach on it, is that also a problem? Or as long as you don't touch the subject, you're good?
Well, at the moment, Hike, we don't know, right? Because that case hasn't been brought up. The court was deciding, and this court, I have to say, I know some people think the court is extreme. I think the court is actually, at least in the religion area, they try to be pretty narrow about things. So in this case, they say, hey, look, we're signaling to you all, those of you who read the footnotes, we're signaling to you that we're not addressing that case. That's not what this case is. Maine didn't say that. Maine just said, if you are a religious school at all, per se, you can't get the money. And that's unconstitutional because that is targeting religion for disfavored treatment.
Got it. So the ramifications of this now is all states, all Christian schools or religious schools or institutions across the country could get government support, funding, or is it more of this nuance where if there's no school and they decide to pick a religious school, they could get subsidized?
So I would say the principle is, if the government decides to provide tuition assistance for private education, it cannot exclude religion per se.
Got it.
Of course, the state doesn't have to do that. State could say, we're not going to subsidize private education. We think our public schools are just great, and that's where our tax money goes, and we're not going to subsidize you if you decide to check out of the public schools. But if they do, look, there was another case that was very similar to this. You might know this case involving the playgrounds. This is a case from a few years ago, in which the state of Missouri was giving benefits to put rubberized surfaces on kids' playgrounds, so kids don't hurt themselves. When I was little, it was just concrete. Nobody cared about kids hurting themselves. That's
why the younger generation is so weak because of this stuff.
Well, okay, that's another podcast.
That's another conversation.
Right. But the Missouri said this cannot go to a religious school, right? We're not going to. We won't give you money to protect the playgrounds in religious schools, and the Supreme Court said you can't do that, right? Again, that is signaling out religion for disfavored treatment under a public benefits program. And that is unconstitutional. That's a violation of the Free Exercise Clause. So in a way, this latest case from Maine just kind of follows from that, except it's not about playgrounds, it's about schools themselves.
Wow. And then there's this third big.
Can I just hike one last thing?
Course.
And I said this is kind of an earthquake because, of course, there had been the thought before that state money cannot go to religion, period. Right. That because that would violate the separation of church and state. And so the court is now moving away from that, right? Saying, well, if the money is going to the schools, to the religious schools, on the basis of private individual choice, and it's just a matter of equality, then you can't stop it, with one exception, which I think you'll be interested in. There's a case called Locke versus Davey from, I think it's the 1980s, in which the Supreme Court said there was a law, I think it was Washington State, which had scholarships for higher education. And, if you were a smart kid, you get a scholarship from the state to apply to your university program, but it cannot go to training of ministers. And
wow.
So if you're at Princeton Theological Seminary, you can't use it, but you could use it for, I don't know, Princeton Engineering School, something like that. And the Supreme Court said that is constitutional because historically the framers were especially concerned about money going from the government to the clergy or to clergy training. So they've carved that out. You can still exclude clergy training, but you can't exclude religious education generally.
Fascinating. Yeah, because I think there's this interesting thing happening in the Christian school world where I know of undergraduate schools shutting down, religious higher education in trouble. But it seems like because of all the stuff with the pandemic, with teaching 7-year-olds transgendered ideologies, a lot of people, whether they're religious or not, are now doing more of the homeschooling and private schools.
Yeah.
So there seems to be an uptick on the elementary level, but on the higher education level, there's a decline happening.
Yeah.
And it's just interesting.
Well, this case is going to really help those elementary school at the level of elementary schools. It's really going to help them because now they'll be able to apply state money to those schools too.
Fascinating. And then there's one more pretty big case that happened as well. This was related to, was it a cake company?
No, cake company was a few years ago. This is a website designer.
A website designer for, was it weddings?
Yes, weddings. There was a case, Hike, you're right. There was a case a few years ago called Masterpiece Cake Shop, also from Colorado.
Okay.
And that involved a baker. But this one is from Colorado, but it involves a website designer. This is called 303 Creative, which is the name of the company.
What was that about? What led to that going up to the Supreme Court?
So 303 Creative, this is a web designer. I think her name is Smith. Yeah, Lori Smith is her name, but her company is called 303 Creative. She's in Colorado, and she has a website design business. And she wanted to expand that to do wedding sites. But she was concerned because Colorado has an anti-discrimination law, like many states do, that prohibits discrimination in public accommodations. That is basically businesses open to the public, restaurants, hotels, things like that, including discrimination based on sexual orientation. She did not want to do websites for same-sex weddings because she said, as a matter of her religion, she was opposed to same-sex weddings and she did not want to endorse them through her work. And she said, but I can't start that I can't go into that business because Colorado will then prosecute me for violating the anti-discrimination statute. And Colorado kind of said, yeah, we will, right? So she brought a lawsuit. It's a kind of a technical thing. She brought a pre-enforcement challenge to the statute. Most of the time, you have to wait until they actually prosecute you before you can challenge it. But she brought a pre-prosecution challenge because she said, we all know what's going to happen, right? There's really no point in my going through this because as soon as I do this, they're going to start suing me. And the Supreme Court said, okay, we'll consider your case now, even though it hasn't happened yet because everyone kind of knows what's going to happen. So Colorado said, look, and her argument was a free speech argument. It was the government, so not a free exercise argument, not a free exercise of religion, but a freedom of speech. The government, she said, the free speech clause means the government cannot compel me to say something that I do not believe. And if they require me to do websites for same-sex marriages, that is compelling me to say something I don't believe, namely that this is a valid marriage. Now, that's my religious belief. It's my religious belief that is compelling me or that is preventing me from saying that. But strictly speaking, it was a free speech case, not a free exercise case. State of Colorado said, this isn't free speech at all. This is business. This is conduct. You're just selling a service. And, there's maybe an incidental impact on your speech, but this isn't about speech. This is about a commercial service. And our law is you cannot deny services based on sexual orientation. And that is a compelling interest. We have a compelling interest in rooting out discrimination in this state. Okay, so that's what the case was about.
Great. So what was the ruling, and what are some of the implications of that ruling?
Okay, so it got to the Supreme Court, and the Supreme Court said that the web designer wins, that this would be a violation of the First Amendment. Why? It said, first of all, it said this is pure speech. And interestingly, so I don't know how many of your listeners are lawyers, but this was an example of how maybe Colorado made some litigation mistakes, because Colorado stipulated, which is a fancy way of saying Colorado agreed for purposes of the record, for purposes of the argument. They agreed that this was her speech, that this was, in fact, not just a commercial service, that this should be considered her speech. They also agreed, as she said, that she did not discriminate against gays and lesbians. She would be happy to design websites for gays and lesbians. She just didn't want to design wedding websites for same-sex marriages. So her objection was not to the customer, it was to the particular message that the customer wanted. And Colorado agreed to all of this for purposes of argument. Maybe looking back on it, their lawyers maybe made a mistake from their perspective. But so the Supreme Court said, well, okay, given these stipulations, this is her speech, right? It's not just a commercial service. This is her pure speech. Number two, we have a long tradition in this country. The government cannot compel people to say what they don't believe. Now, Colorado said we have a very strong interest in ending discrimination. And the court said, okay, we accept that. We accept there's a strong interest in preventing discrimination in the marketplace. But that doesn't mean you cannot apply that interest and force people to say what they don't want to say. So she wins. It was, again, a 6-3 ruling. And I should say all of these rulings, the dissents were quite impassioned. The dissents were written by Justices Sotomayor and I think by Justice Breyer, additionally, in one of the cases. Especially Justice Sotomayor's dissent was quite emotional. Like, for example, in this case, she said, this is a backlash. We are going backwards in this country. That, the idea that a business can discriminate against gay people is moving backwards. And this is a very sad day, she said. But the court said, no, that's not what's going on here. She's not discriminating against the customer. She just doesn't want to say something she doesn't believe. That's how you have to look at this case. And so she prevailed.
Wow. So I mean, I think sometimes people get caught up with the specifics of like the Christian versus the LGBTQ, but there's ramifications with all this stuff. So say we mentioned polygamy earlier, a website designer who's non-religious just doesn't endorse polygamy. Does this have ramifications for a secular person who doesn't want to endorse polygamy? For example?
I mean, for sure. What about someone who said? And by the way, she said she would not design websites that had anti-Christian messages generally. It wasn't just about this.
Okay, or that.
Yeah, generally. Or look, let's say someone comes in and says, I want you to design a website. I'm having a racist party. And, I've got all the racists and the Klan members, and they're all going to come and, you've got to design my website. Can she say no? I mean, I think it covers that too,
Which is a good thing. And I think people should be excited about that because God forbid, I can't say no to the KKK,
I think the principle will cover this, right? Now, the answer would be, well, okay, but that wouldn't be discriminating, right? Colorado wouldn't stop you there because Colorado has an interest in not discriminating against, among other groups, LGBT. And Colorado has no interest in not discriminating against racists. So they're not going to prosecute you for doing that. But the principle that as a person in an expressive business, I should not be required to say something I don't agree, that would cover the situation I just described. You know what else the dissent said? Well, what about caterers? What about the people who, bring in the furniture for the wedding? What about them? And again, the Supreme Court said, just like in the last case, we're not talking about that, right? There'll be other cases that in which businesses don't implicate the First Amendment. and we'll decide that when we come to it, right? So if there's
So it seems like there's a Supreme Court history of footnote, and it just means to be continued.
or in the text, either way. But
Yeah.
yeah, this is to be. We are, we'd say the sort of the legal cliche is we reserve that case for another day.
We want to stay in business. We're going to keep going. Okay. Amazing stuff. I guess my final question with all this is, how would you define a religion? Because I think there's this assumption when people just say the word religion. I'm as America is becoming more secular, I feel like when people adopt certain ideologies, political parties, there is a flavor of religiosity now to people's worldviews. It just may not have a traditional religious layer to their belief systems. But how do you define a religion? Because this impacts this whole conversation.
Well, it's funny you should ask that, because actually I've just written a piece about this that came out. I think, Hike, that is really the next big issue coming down the pike. It wasn't addressed in any of these cases, but that is, how do we define religion for constitutional purposes, right? Free exercise of religion. That's what the Constitution guarantees you. And you said secularizing. I think you said people are becoming more secular, but sorry, go ahead.
Oh yeah. I mean, statistically, they're becoming more secular, but I feel like they're adopting now new belief systems that are not just formal religion.
I would
yeah.
I would push back a little bit on their becoming more secular. What we see is the rise of the nuns, but those people are, I think, best understood as disaffiliated believers. That is, they check out of organized religion. They don't want to be a part of institutional churches or things like that, but they are quite spiritual, and they have commitments which from the outside sort of look like religious commitments, and they are beginning to show up. So maybe this is another conversation, but in some of the COVID cases, there were people who challenged vaccine and mask mandates, and they on religious grounds. And the court or the prosecutor would say, the government attorney would say, well, what's your religion? And they'd say, well, I don't have a religion. I just kind of believe in something out there that tells me that vaccines and masks are bad and that I shouldn't do this. And up till now, the court has been very deferential about this, saying, okay, well, we'll just assume you're a religion. But some courts are beginning to question this more. Like, well, is that really a religion just because you have some commitment that's divorced from any tradition, that's divorced from any organized body? And I think going forward in the next generation, as we have more and more religiously disaffiliated believers, I think we're going to see more and more of that. I think that's really a question that's coming down the road.
Fascinating. Yeah, because how can they? I mean, it makes logical sense, and I had no idea you're writing that article. I look forward to reading it. So I guess
in First Things if anyone wants to read it.
Yes, First Things is a great resource. So, any encouragement for someone of faith wanting to pursue the law field of becoming a lawyer or a professor? Any advice? Because I feel like sometimes people think that, if I'm going to become a lawyer, I'm going to be this unethical person. There's that stigma, I think, that still exists.
Well, I don't know if lawyers have a monopoly on being unethical people. My sense is there are a lot of such people, and there's nothing in principle unethical with advising people about their rights and responsibilities under the law. So I wouldn't say that, if one is a Christian, one can't be a lawyer. I certainly hope not. There are groups like the Christian Legal Society that, in fact, that look out for law students who are Christians and try to make a home for them. There are many religiously affiliated law schools. I teach at one. So I wouldn't say that just to be a lawyer, and by the way, I mean, I think, Pastor, you come from Protestant tradition, right? I mean, John Calvin was a lawyer. There were plenty of lawyers who have now, maybe he was more of a theologian, but I think he was a lawyer, I think. So I don't think that there's any reason not to. Now, it is true that just like any profession, there may be times in your life as a Christian lawyer where you have some problems because, you may be asked to do things which you object to as a religious matter, or you may feel compelled to represent clients who are doing things that you don't think are consistent with Christianity. And of course, you don't have to accept any client particularly. And those are problems. And I would be, look, I mean, St. Paul says in one of the letters, why would Christians sue each other at all? Aren't you embarrassed to sue each other? You should be settling this in the church. But we know Christians sue each other all the time. So I don't want to minimize difficulties. I'm not sure that those kinds of difficulties don't come up in all kinds of professions.
Yeah, and I think that's kind of part of what this podcast, we bring in believers from different fields, and we want to encourage people to kind of, I mean, this is a very Protestant notion, the priesthood of believers. We need people in the sense of seeing their calling in these fields to bring light to them, and if someone's called to it, do it.
Yeah.
You know, I mean, I'm called into ministry, but I know people are called to be in the field of law or medicine, and like you just said, every profession has gray areas, but that's why I think people needing to stand up for love and grace is even more important.
Well, and justice, and justice, and
justice,
look,
in this case.
and look, well, I mean, this is, I think, by the way, this is also a fascinating topic. I mean, how much, how seriously Christianity has affected the Western legal system. There are all kinds of Christian notions in this, but I would say, again, I don't want to minimize it. I think that Christians are likely to have these questions as lawyers. I mean, I think Christians are likely to have questions just as being living human beings, getting through their day just as human beings. I think it's hard sometimes. These if you're thinking about things seriously, these issues come up quite a bit, not only in law.
Thank you so much, Mark. This was great. I learned a tremendous amount, and I hope everyone who was tuning into the Christ and Coffee podcast just learned a tremendous amount. Thank you so much for listening. Have a great week. Much love. Be blessed. God bless you. Take care.
Thanks so much.
Crazy.